the title of my presentation is The Road Toward Modern Family, our experience. So how was the development and how was rethinking of family in Croatia. I could say we really had turbulences in Croatian family law. In 21st century, it was very tough. In 2003, we had a new Family Act, a very modern one, according to us. It was amended in 2007, and it showed some continuity in historical development, also considering the notion of family. And then Reform 2014 changed the paradigm because it was influenced by the principles of the European Commission of Family Law and European trends. And also in 2014, it was enacted the Act on Same-Sex Partnership. It granted to formal and informal same-sex unions equal position in the whole legal system as marriage. In 2014, Constitutional Court suspended the Family Act due to so many inconsistencies, but it wasn't pronounced that it is against constitutional norms. But it had so many legal holes and unclearness, some of it you can see on your screen. And then it was enacted New Old Family Act 2015, New Old because it kept so many solutions like the Family Act of 2014. When the government changed, it was constituted a working group that on 2017 proposed new Family Act, and it was really dramatically withdrawn by Premier's decision during public governmental session because of the definition of family, and it is why it's so interesting for our conference. This proposed definition of family was really narrow, I have to admit. It allowed it, in terms of this act, the family consists of mother, father, and their children, mother with a child or father with a child, although do not live together, and other relatives who live with them. So the spouses were not even marital, considered to be a family, and people really felt offended. Maybe it was, I now regret a political mistake to try to propose such definition, but because government was not ready to accept critics. Nevertheless, this definition was meant to serve only for the purposes of Family Act, because we also had another many acts and legislation that defines the status of family member, and one of them is the Act on Same-Sex Partnership that pronounces family life relation between two persons of the same sex as family life. And for example, there are so many other acts, the Act on Protection Against Violence in Family in 2019, as family members also concerns to be a wide number of persons. Also, people who live in same household, not only relatives. We had the concept that the child is the constitutive part of a family and also the kinship. And now it's the problem, is the question who can be the mother and who can be the father. It's as usual, mother is the motherhood is established by presumption. Since 2014, it's presumptio juris. Till 2014, we had presumptio juris et de jure because we tried to strengthen the political decision and legal tendency that surrogate motherhood is not permitted. Though we have people who use it, wrote a little bit later about it. Also, motherhood can be established by judicial decision, and these are two main principles. We had also till 2014 possibility to recognize the motherhood. It's quite rare in other family law national systems, but it was it had some historical reasons. While birth registers were destroyed, also during Homeland War. And it was easier there to establish motherhood than to go through court proceedings, and it doesn't serve its purpose anymore. And father status is also can be determined by presumptio juris, also by recognition. Interesting also for a child conceived in wedlock, since 2014, it applied German system and by judicial decision. So, two key questions are who may be a parent and who may be a holder of parental responsibility. So there are two different legal institutes for my opinion as well. So a person who is entered as a mother or a father, of course, into a birth registry, and I also wrote in my country report that also included some other aspects, international aspects. It is not very well known. I was a member of commission who drafted a recommendation on the rights and legal status of children and parental responsibilities in Council of Europe, 2011. It was ad hoc commission, and there was a principle too for the purposes of this recommendation. Parents mean the persons who are considered to be the parents of the child according to the national law. It was quite controversial in this time, and although this draft recommendation reached Committee of Ministers, almost, it was stopped by lobbying, as I heard later, of Vatican and Russia. So, because of this freedom for each state to consider to determine who will be the parent. 10 years later, I don't know how it will work. And no recognition in Croatia, there is no recognition of a foreign registry of birth if a single man or two men is required to be entered into a birth registry in Croatia, because the Ministry of Administration requires medical documents who is the mother of this child. But I think, as far as I know, that this will be also challenged. And who may be a holder of parental responsibilities? We also, of course, have Brussels II-bis Convention, who defines the holder of parental responsibility, and also we have Convention on Contacts. But we also managed to keep restrictive definition, because they may be biological parents and adoptive parents. In the Solution of Family Act 2014, there were also mentioned other persons, physical or legal persons, and as academics challenged this, because we said that in the core of notion of parental responsibility must be a parent. So we managed to keep this to let it out from our Family Act, from our national legislation. Also, the same government enacted, proposed it, and later Parliament enacted it. Who may be a parent by a Croatian law? Biological parents. They may be a child may be born naturally or by medically assisted procreation. So we know it helps people who can't become parents. And beneficiaries may be of medically assisted procreation, maybe a woman and a man who are in marriage or in a stable non-marital union. A woman not living in a marriage, non-marital union, or same-sex union, whose treatment of infertility failed or has no prospect of succeeding. That means that so-called social infertility isn't reason to allow a woman to use medically assisted procreation, I mean donor. Although in practice, no one. I think it's a great part. So physicians allow a woman to use. I mean, not to use in Croatia because it isn't possible because of some other reason, not because of legislative reason, but they allow them to go on under financing of health funds to Macedonia or some other countries. Like Czech Republic and so on, and also adoptive parents may become parents. They may be a woman and man who are in marriage or in a non-marital stable union. A person who is married upon consent of the marital or non-marital spouse, and a person who is not married, but this is exceptionally if this is in the best interest of the child. We tried to, in a proposal 2017, that was a little bit conservative, to restrict the possibility for non-marital couples to adopt a child only if there is in the best interest of the child, because we try to promote marriage. And the second reason is, according to practice of European Court for Human Rights, it is fear that same effects of that have and legal effects that enjoy heterosexual couples may be applied on same-sex couples, not only in other legal branches but also in field of adoption. Later we'll see, and or also in field of medical assisted procreation. It's interesting to know that stepmother and stepfather have right to contact, right to make everyday decisions with the consent of the parent if he or she lives with a child in the family, the stepfather or stepmother, and right to maintenance. And they have no parental responsibility at all unless they are entrusted if a parent is not present. So they can be entrusted like any other person. They have no privileged position in family law system toward children. Parents, same-sex partner has all these rights, and also but don't have right to maintenance. It was a lack in the Same-Sex Act. He has no duty to maintain his same-sex parent's child. Neither has right to receive maintenance. The Same-Sex Partnership Act introduced two forms of parental responsibilities. One is right to exercise parental responsibilities. It can be by a court decision or entrusted by biological parents or parents who alone or both exercise parental responsibilities. It can be together with parents or instead of its parents by court, of course, and if it is instead of its parents. And it's also not quite clear that because there are no prescribed reasons for shared parental responsibilities by biological parent and same-sex partner. And because it's quite different, and in this part is the Same-Sex Partnership Act contrary to Family Act, because only parents can exercise parental responsibilities according to Family Act enacted in 2015, 1 year later. And also, only if parents agree, they can share parental responsibilities. It is not possible if there is no agreement. And here it's not prescribed as this. And also it was introduced, in fact, adoptio minus plena, so-called partner care, that has all effects as adoption, and it's only another name for it. Why I labeled my title towards the title of my lecture towards modern family, because the Constitutional Court in 2020 ruled that same-sex couples have to be allowed to become foster parents, but after a couple of years of legal fight, these two gentlemen managed to become foster parents for 2 children. And also they succeeded to go to procedure that allow them to get the license to adopt. So a certification that are applicable as adopters. Although this is contrary Family Act, because same-sex couples are not allowed to adopt a child, neither together, not a person who lives in the same-sex partnership can adopt the child. That was the rule of administrative first degree court, because it followed the argumentation of Constitutional Court that courts have to interpret legal norms in the spirit of human rights. I haven't chance to see this first degree decision, but I know but I doubt if there is there are mentioned children's rights. And so now, so far as well, these 2 gentlemen are not finally, but prospectively will be allowed to also get the license to adopt. That doesn't mean that they have the right to adopt the child, because there is not enough children for heterosexual couples. There are 6 heterosexual couples in this moment waiting for concurring for 1 child to adopt in Croatia, like in many other developed countries. In this presentation, it's also interesting that European Commission started consultations on the topic of recognition of parenthood between the EU member states. A colleague from our chair got invitation for one consultation body to take part into on this initiative on recognition of parenthood between member states. And this is something that raises question if you have if you have one regulation in a national state, what does it mean if somebody gets a parental status abroad, and then no? What can we do then? We had many, we used many words on parenthood, but at the end of this presentation, I would like to ask myself and also everybody, where disappeared children, because we first had since since Convention on the Rights of the Child pedocentrical world. Now, when our rights now it seems to me that rights of adults are wealthier, so they gain more priority. And this discussion should be continued, okay, accepting social reality. There are many so-called rainbow families, and we have to regulate these relationships somehow, but we shouldn't forget children in these discussions. And I didn't have a look how much time I used it. I hope you could hear me. Thank you very much for your attention. And I'm looking forward to discuss later, because prior members opened so many interesting questions. This was very interesting today, this conference. First, I admire family-friendly Hungary, also due to the legal system and to the demographic measures. I've already read about this, and I'm a little bit jealous, I have to say, although I have only one child myself. But it's a pity that Professor Chasso is not here. He had a very interesting approach toward a difference between right to family life and family. That is what once I argued with our judge, Professor Weich, she was a judge in Strasbourg, because it seemed to me then that if somebody is entitled to right to family life, that doesn't mean that he's a part of family. It's maybe just linguistic acrobation, but because I thought like foster parents had right to family life, that was accepted in Strasbourg, but they're not family in a legal way when we talk about constitutional meaning of family. This is something maybe we could discuss, because that leads to another thought that we need to take care of legal terms we use. For example, in Croatia, we made the difference between heterosexual and homosexual partnerships, de facto, because there are different names for purpose, because extramarital unions are a constitutional term, but in our constitution from 1990, they are not mentioned to include homosexual unions as well. So we have another term, homosexual, same-sex partnership. I don't advocate for restricting mutual rights of same-sex of same-sex partners in the field of their mutual relationship and regarding effects in the public sphere, but there is also a difference. And I would also like to suggest, it was very interesting link. It was very interesting presentation of our colleague who is a psychologist. Sorry for not knowing your names, Professor Visontai Sabo. Now I see. Thank you very much. How to promote marriage to be more stable. For example, we gave up of trying to preserve marriage before divorce in our legal system in the Act of 1914 and 2014 and 2015. And I have some statistical data. Then, when there was such institute in our legal system, some couples gave up of divorce. So it had some. It was some tool specifically in a country where people are not very keen of psychological help, like family therapy and so on. So it was knock knock. Please, let's try to solve your marriage. And also, I would like to include, maybe there is huge problem of violence in family. We don't need to protect family as such in any case. So it would be also an interesting topic for us family lawyers, as well, not also from our colleagues that are professors of criminal law. And also, I find in demographic sense alimony extremely important, that parents are 100% secure that if their marriage or union disparts, crashes, that there will be sufficient, that children will be economically safe. And this is, as far as I know, a huge problem in all countries, also in Western countries. We try to introduce something like alimony fund, subsidized by the state, but these are just small pieces of goodwill for the state, and it doesn't work as well as it should. So thank you very much for your patience with all us professors who constantly have some questions and maybe sometimes don't understand as me as well everything what is required for me. But I'm so happy that I had chance to cooperate, and this cooperation will continue. I feel this very exciting and also helping me in my professional development. I always forget how old I am. So thank you. Everybody, especially also to Institute.